Welcome back, everybody. In this session, we will be talking about Order 27. This is specific. This is a special type of suit against against special body. It is suits by or against the government or public officers in their official capacity. Why do we have these special provisions? Because in CPC we are taking care of some part of the since civil suits are there in the CPC and their adjudication requires a lot of time, and if there is government involved, and there shall be a government involved many a times there will be government involved as plaintiff or defendant, then we can't just make them go through the hassle of lot of time pendency of the cases. We need to make sure that they are not being hampered by this. Why? Because it's the public's time that is being wasted, and we don't want to waste the public time. We want to save it. We want to save the pendency of the cases. We want to reduce the conflict. So is there any provision, like we'll be talking about this in this relevant order as well as relevant section. So if you guys can comment down what is the section pertaining to the suits against or by the government officers. So suits by or against the government, Order 27, Rule 1. In any suit by or against the government, the plaint or WS shall be signed by such person as the government may, by general or special order, appoint in this behalf, and shall be verified by any person whom the government so appoint. Person authorized to act for government, person being ex officio or otherwise authorized to act for the government in respect of any judicial proceeding shall be deemed to be recognized agent. Next, plaint in suits by or against government. In suits by, instead of inserting the plaint, name and description, the place of residence of the plaintiff or defendant, it shall be sufficient to insert the appropriate name as provided under section 79. The section 79 deals with the your suits against the government, and it says if the central government is being targeted or if the suit is by or against it, then Union of India, and if the state, then the respective state government. Agent by government to receive process. The government pleader in any court shall be agent of the government for the purpose of this. Fixing the day for appearance. The court, in fixing the day for the government to answer the complaint, shall allow reasonable time for the necessary communication. But the time shall not exceed 2 months. Shall not exceed 2 months in aggregate. Alright. 2 months is the time period that is asked many a times in your prelims. Government to, and why is the time? Fixing the day for hearing to answer the plaint shall allow reasonable time for the necessary communication with the government through proper channel, and for the issue of instructions to the government notice period they are being talking about. Government to be joined as party in suit against public officer. Where a suit is instituted against a public officer for damage or the relief in respect to alleged have been done by him in official capacity, then the government shall be joined as party to the suit. Duty of court in suits against the government of a public officer to assist in arriving at the settlement. This is 5B. 5A. If the suit is against the government officer in the official capacity, then government would be added as a party. 5B, they are being saying that it is necessary, it is the duty of the court to arrive at the settlement, to help them arrive at the settlement. In every suit or proceeding to which the government or a public officer acting in this official capacity is party, it shall be the duty of the court to make in the first instance every endeavour where it is possible to do so consistently with the nature and circumstances of the case, just as the parties in arriving at settlement subject matter. And if any of the suit or proceeding at stage appears to be the court, then there is a reasonable possibility of settlement between the parties. The court may adjourn the proceedings for such period as it thinks fit to enable attempts to be made to effect such as settlement. The power conferred under the sub-rule 2 is in addition to any of the powers to adjourn proceedings. Attendance of person to be able to answer questions relating to the suit against the person, government. The government may also, in any case, if the government pleader is not accompanied. Government pleader is not accompanied by any person on the part of the government who may be able to answer the material question and direct the attendance of the such person. Extension of time where the defendant is where were we? Just a second. Yes. Where the defendant is public officer and receiving summons considers it proper to make a reference to the government before answering the plaint, he may apply to the court for grant such an extension of time in summons as may be necessary and able to make such a reference and receive orders, to proper channels. So he would say that it would require time, because it would go through all the channel, go to the highest person and answer, and then we'll go back, we'll return. So it takes time. Upon such application, court shall extend as it appears necessary. Procedure where the government undertakes the defense of a suit against public officer. The government, upon being furnished with authority to appear upon such application, cause notice note of the necessity. No application or before, and the case shall proceed in the suit between the private parties, as like private parties. Okay. The defendant shall not be liable to arrest and stop to attachment, otherwise and the execution of decree. We'll read these as special provisions. Then no security to be required from government or public officer in certain cases. No such security. This is a special provision. No such security to be required from the government or public officer in certain cases. Order. This is 41. Rule 5 and Rule 6 shall be required the government, or when the government has undertaken defense. 8b talks about definition of the government pleader in relation to any central government and the state government. Alright, there is nothing more in this. We have done 27. We haven't done 27. Will not do it. I am thinking of giving you particular notes of certain topics, like I have written here as well. I will try to give you. Okay, in the next upcoming sessions we'll be going topic wise, and we'll also be preparing answers for mains simultaneously. Okay, we'll prepare answer for mains, and we'll be doing pre from the Bail Act itself side by side. All right. Death, marriage or insolvency of parties, that is 32, that is abatement. Okay, so we have done 33. 33 was, sorry, this is 22. Why I have written 32? This is 22, abatement. 23, what happens after abatement? We have withdrawal or adjustment of the suits. Then 24 was payment into the court. 25 was cost. 26 we have done commission. We have done these provisions, that's I'm not reading with them again. This is the 22, death, marriage or insolvency of the parties. Okay. No abatement by parties' death if right to sue survives. The death of plaintiff or defendant shall not cause a suit to abate if the right to sue survives. Procedure where one of the several plaintiffs or defendant dies and right to sue survives. So rule 1 says that suit won't be abated if the right to sue survives. Now, where one of the several plaintiffs or defendant dies but right to sue survives. So where there are more plaintiffs, any of them dies, where the right to sue survives alone or against the surviving defendants, the court shall cause an entry to the fact and shall proceed at the instance of surviving plaintiff against the surviving defendants. Procedure in case of death of one of the several plaintiff or a sole plaintiff. Where one of the two or more plaintiffs dies and right to sue does not survive to the surviving plaintiff alone, and the right to sue survives or a surviving plaintiff dies, the court on application causes LR of the deceased to be made party and shall proceed with the suit. Remember this. LR, sole plaintiff. If plaintiff dies and right to sue survives, then LR. Rule 3. Where the time limited by law, no application is made, the suit shall abate. If within the time prescribed, they have not made the, I think it is 90 days or 60 days. Please check once. Okay, write down in the comments if I get this wrong. Then the suit abate as far as the deceased is concerned, and the application defendant, the court may award him the cost which may have incurred in defending the suit to be recovered from the estate of the deceased. Now what will happen? The suit as far as the deceased is concerned, and on the application of the defendant, the court may award him cost. Now defendant would be liable for the cost if the suit is abate. Now from where will the cost will be awarded? Recovered from the estate of the deceased person. This is important. In procedure in case of death, now we have defendant. So where one of the two parties does not survive or survives, an application shall LR of the, so if defendant and right to sue survives, then LR to be substituted. Okay, any person made so party make any defense appropriate to his character as LR of the deceased man, where within time limit no application shall against, and the court will then may exempt the plaintiff from necessity of substituting the of any such defendant who has failed to file a written statement or who, having filed it, has failed to appear, contest the suit at hearing. The judgment may in such cases be pronounced against the said defendants, notwithstanding the death of such defendant shall have the same force and effect as it was pronounced before the death took place. Now this is also important. What it says that this is plaintiff, this is defendant. Okay. Now this person has deceased. So the court can exempt the plaintiff to substitute the LR. Now who will file the application? Read this again. When one or two dies, right to sue survives, or defendant right to sue survives, the court application within such deceased to be reduced. Okay. So कोर्ट एग्जेम्प्ट कर सकती है सब्सटीट्यूट करने के लिए LR ऑफ एनी सच डिफेंडेंट. फर्स्ट, इफ ही हैज़ नॉट फाइल्ड WS or he has filed WS but failed to appear, the judgment may be pronounced against the deceased defendant and it has the same force as if it pronounced if the death took place. Okay. Where the plaintiff was ignorant. Now, where plaintiff was ignorant of the death of the defendant and could not for that reason make an application for the substitution of the LR of the defendant under this rule within the period specified in the Limitation Act, and the suit has in consequences abated, and the plaintiff applies after the expiry of the period under specified in the Limitation Act for setting aside abatement and also for the admission of the application under Section 5 of the Act, that is condonation, on the ground that he had by reason of such ignorance sufficient cause for not making the application of the period specified in the said Act, the court shall, in considering the application of Section 5, have due regard to the fact of such ignorance if proved. Okay, so the court would not be so strict about that. Procedure where there is no legal representative. Now what will happen? There is no legal representative. If any suit, it shall appear to the court that any party who has died during the pendency of the suit has no LR, the court may, on the application of any party to the suit, proceed in absence of the person representing the estate of the deceased person, or may order appoint Administrator General or an officer of the court, such person having to represent the estate for the purpose of the suit of any judgment was subsequently given and made. The suit shall bind the estate of the deceased person. Same extent it would have the personal representative. Before making an order, may require notice of the application for to be given, having an interest in the estate, and as representative willing to, and person is willing to be open, has no interest, adverse interest. Determination of question as to the LR, where a question arises as to whether any person is not LR, such question shall be determined by the court, provided that where such question arises before an appellate court, the court may therefore, determining the question, direct any subordinate court to try the question and return the records. So if the question arises at an appellate stage, then the appellate stage what the appellate court would do, subordinate court को दे देगी कि तुम इसको ट्राई करो, रिटर्न करो अपना जो भी आपके पास फाइंडिंग आई है, and the appellate court may take into consideration determining the question. No abatement. This is so important prelims question. This comes under your prelims various times. The order 22 rule 6 says no abatement by reason of death after hearing. Notwithstanding anything contained in foregoing rules, whether the cause of action survives or not, there shall be no abatement by reason of death of either party between the conclusion and hearing and pronounced judgment. The judgment may in such case be pronounced death and shall have the same force before death. So not to be abate. This is also important. This also comes under 7. Order 22 rule 7 talks about suit not abated by marriage of the female party. The marriage of the female plaintiff or defendant shall not cause the suit to abate, but the suit may notwithstanding be proceeded with the judgment, and where the decree is against the female defendant, it shall be against her own. Where the husband is by law liable for the deaths of his wife, a decree may, with the permission of the court, be executed against his husband also. But read this again. Law liable, husband is liable, then only husband would be, if liable, then only the decree would be executed against him. In case of a judgment for wife, the execution of the decree may, with the permission of court, be issued upon the application the husband, where the husband is by law entitled to subject matter of the decree. Where plaintiff's insolvency bars suit, this also comes. Insolvency of person in any suit which the assignee or receiver might maintain for the benefit of the creditors shall not cause the suit to abate unless such assignee. This just 8 talks about no abatement when the plaintiff is Yeah, which the receiver might. Court shall not cause a suit abate. Yes. All right. Effect of abatement or dismissal. 9 is effect of abatement or dismissal. Where suit abates or is dismissed in the court. No fresh suit shall be brought on the same cause of action. HOD घाटा लग गया. The plaintiff or the person claiming to the LR or the signee may to set aside the abatement, and if it is proved that it was prevented by sufficient cause for containing the same, the court shall decide the abatement and dismiss. The provision of section 5 of the Limitation Act shall apply. Latest to defense based on procedure in case of assignment before the final order. In other cases, assignment. Duty of pleader to communicate. Now it is a duty of the pleader to communicate the court data to the party. So this is 10A. This comes directly, which rule tells you about this rule 10A. So whenever a pleader appearing for part of the suit comes to know the death of the party, he shall inform the court about it, and court shall thereupon give notice of the death to the other party. One party pleader, court, another party pleader. All right. Currently, the pleader and the deceased party shall deem to subsist, and this is also important. And the contract in the pleader and the deceased party shall deem to be subsist. Application of order to appeals. In an application, and so the word plaintiff shall have to include the word appellant and the defendant or respondent and the suit and appeal. Nothing in rule 3, 4, 8 apply to the proceeding and execution of decree or order. Now what is 3, 4 and 8 will not apply to execution. 8, 3, 4. 8 is your assign insolvency. 8 is your insolvency. 4 is your procedure in death of one of the several. Okay, so they won't be applicant in the execution of decree and order. This is important. Okay, 3 plaintiff, defendant, insolvency. Okay. So we are done with order 22 as well. And in the next class, we won't be doing 21. We will be doing 21 is so long. We'll just give the only will do important provisions of 21. This is 21. We have done 21 a little bit. Then we have 20A. Yes, we'll do 20A. That is costs. And 20, which is judgment and decree. Very important. So in the next class, be ready with your pen paper, because we are going to mark and write some mains answers as well. See you. Thank you. A big thank you.